President Uhuru Kenyatta, through his lawyers led by senior counsel Fred Ngatia, has claimed that Raila Odinga, through a response filed before the court, admits to have abandoned the rerun election and that there cannot be a fair hearing if this irregularity is allowed to go on.
A respondent who now says he is answering a petition, but what he does in essence is to file a new petition. My lords, I have absolutely no doubt, my lords, that reading this answer from paragraph 30 all the way to the relief, you will come to the only conclusion: this is another petition.
In his defense, Raila Odinga, through lawyer Paul Mwangi, says the allegations against his character by Uhuru Kenyatta call for a response, and thus his being enjoined in the case is well within the law.
They say that by the time we filed the response, we locked them out from replying because the time for making responses was over. That applies to what they say in the submissions, because I don't know at which point they also anticipated that the fourth respondent is going to answer to those things they have said in the submissions. So the same accusation they are making of the fourth respondent is the one they themselves have already committed.
The advocates assisting us with the documentation have been denied entry into the courtroom.
The Jubilee Party is also seeking to be enjoined as an interested party in the case.
The supporting affidavit, I will demonstrate very quickly how we have met those tests. In paragraph 6 to 15, we have shown you what our identifiable stake is. And essentially, it is this. The petition number 3, which we have perused closely, deals mainly with extensive acts of violence and intimidation, which created lots of chaos and mayhem and bedlam across the country, and amounted, in effect, to very serious electoral offenses.
But according to lawyer Jackson Awele, the current petition as is does not fit the bill as a presidential petition.
In the event, my lord, that you find that you do not have jurisdiction, or that the issues that have been raised in the petition fall outside of your jurisdictional limits, then, my lord, in the timeless words of Nyarangi J.A., in the honors of M.V. Lillian S. versus Caltex Oil Kenya Limited, my lords, you must down your tools.
Earlier in the day, the bench heard applications seeking to have internal IEBC memos expunged as evidence in the case. Uhuru Kenyatta argued through his lawyers that the material was not acquired within the confines of the law.
The basis of seeking this request is that the memos were unlawfully and illegally obtained by the petitioners.
In her defense, Julie Soweto, the advocate for the petitioner, argued that the documents were important.
That justice shall be administered without undue regard to procedural technicalities. This is a procedural technicality.
Fred Ngatia, the lead counsel for Uhuru Kenyatta, also raised an issue with the use of information from an affidavit by John Ngondi that had not been placed as part of the evidence, and thus wanted the paragraph struck off the petition.
That affidavit, even today, has never been filed or served.
The IEBC has said that getting information from all the registers and diaries from polling stations across the country will be a tasking job that will need more than 2 weeks to accomplish, and that getting that information is seeking to introduce new evidence to the case. Leila Mohammed, NTV.